Hi, I'm Joryn Jenkins, and I'm talking about the collaborative divorce posters that I've created, both to help my clients choose which divorce process they want to get divorced and also help their spouses choose which divorce process they want, but also often to help my clients get through the divorce process, the collaborative process, and get to the finish line. This particular poster is a poster I've made of a table that I think all collaborative professionals have seen. It's not, we never see the same table twice, but it's the same idea. You've got the collaborative divorce process on one side, and you've got the litigation or courtroom process on the other side. And it's a table that shows the differences between the two processes. So what's the judge's role or the decision maker? What's the atmosphere in the room? What's the level of conflict between the spouses? What's the cost? What's the time? What's the expert's role? You can see that I've got all of the usual comparisons made. And of course, I've also got figures to help the clients, images that help the clients understand what it is we're talking about. Many people think in images, they don't think in words, they remember in images. It helps people remember more easily, even if they are a wordsmith. So what's the nature of the process, the conflict of interest in the process, and what are the skills required to get through the process? And so you can see, I'm not going to read the whole thing to you. You can find the poster at www.jorynjenkins.com, but I'll discuss a couple of the differences, and then you can go and see the rest of the specifics there. So the judge's role, for example, the decision maker. You and your spouse both control the process and make decisions. The judge only enters a divorce decree approving your agreement. In litigation, a judge who doesn't know either of you or share your values controls the process and makes the decisions. He enters a divorce decree controlling your life until your last child is no longer dependent. What's the atmosphere? In collaboration, it's interest-based, it's team and goal-oriented, and it's safe. In litigation, it's positional, it's adversarial, and it's hostile. What's the level of conflict? In collaboration, you both pledge, and the team supports you and enables mutual respect and transparency. In litigation, it's hostile, adversarial, and disrespectful. The process is disrespectful. Discovery process discourages candor and transparency. Let's look at the costs. In collaboration, it's fairly manageable expenses, usually less than litigation. I have never had a case that even approached the cost of litigation. And the team use of experts is financially efficient. In litigation, unpredictable costs often escalate rapidly. Post-judgment litigation is common and costly, and adversarial expert battles are financially inefficient. Let's talk about the lawyer's role. Lawyers problem solve in collaboration to help you both generate an interests-based win-win agreement. What's it look like in the courtroom? Lawyers fight to win, but someone always loses, often both lose, in a court-imposed lose-lose judgment. And finally, let's look at the conflict of interest. I want to talk about that specifically. Lawyers are disqualified if the process fails, if either of you opts for court. Their only interest is to help you reach agreement. In the courtroom, lawyers profit. In other words, they make more money if you do not agree and you continue to litigate. So there's a built-in conflict of interest in the courtroom that lawyers don't suffer from in the collaborative process. I think that's very important. And the nice thing about this poster is my clients can look at it and they can ask me questions, or we can go through it item by item, which I sometimes do, so that they understand every aspect of how the courtroom differs from the conference room, the collaboration. I think that's critical to enabling your client to choose the process that's right for their family.